Good morning and welcome to the Supreme Court of the United Kingdom. Today, we are hearing an appeal in a case concerning value-added tax. The appellants are Balhousie Holdings Limited and the respondents are the Majesty's Commissioners of Revenue and Customs. The issue concerns the interpretation of a statutory provision which imposes a charge to VAT when the purchaser of heritable property in a zero-rated transaction disposes of its entire interest in that property to a third party within 10 years of acquiring it. Today, the appellant taxpayers are represented by Mr. Roger Thomas QC and Mr. Philip Simpson QC. The respondent commissioners are represented by Mr. Kieran Bell QC and Mr. Ross Anderson. Before inviting the appellants to open their appeal, I will introduce the panel. I am Lord Hodge. Good morning. Lord Briggs.
Good morning.
Lady Arden.
Good morning.
Lord Sales.
Good morning.
And I'm delighted to welcome Lord Carlaway, the Lord President of the Court of Session.
Thank you. Good morning.
I now invite Mr. Thomas to open the appeal.
My Lord, my Lady. If I could start with a summary of our argument, it goes as follows. First, the statutory purpose of zero rating supplies relating to care homes is to reduce the cost to the final consumers, the care home residents. Secondly, the purpose of the supervisory provisions in Part 2 of Schedule 10 is to secure that such zero rating is available where, but only where, the purpose for which zero rating was granted in the first place continues to be satisfied. Thirdly, the manner in which this is achieved by the supervisory provisions is by requiring an adjustment, first of all, where the recipient of the zero-rated supply has wholly disposed of any interest he may have in the premises. And secondly, where without wholly disposing of his interest in the premises, he nevertheless no longer uses the property wholly for the approved purpose. Fourthly, as a matter of common sense, we say the interpretation that we place on the phrase disposal of P's entire interest in paragraph 36.2 better conforms to the legislative purpose of the zero rating provisions. And this may be tested by comparing the outcome for residents of the care home, the final consumers for whose benefit the zero rating is provided. If one accepts the Commissioner's approach, their cost of accommodation will increase. If one accepts Balhousie's approach, it will not. On Balhousie's approach, it is only where P, as it is called under the relevant paragraph, entirely disposes of all interest in the premises and has no interest left in those premises that paragraph 36.2 will engage. But until then, whether P retains its zero-rated benefit depends on whether or not it continues to use the premises wholly for relevant residential purposes. None of this requires a consideration of any European principles beyond those regulating the circumstances in which a member state may retain zero rating for certain supplies. We are dealing with a domestic provision. However, the Commissioners insist that taking account of Balhousie's retained interest in the care home in applying paragraph 36.2 would offend what is said to be a fundamental principle of European VAT law, which is that one must consider every supply independently and without regard to whatever else may subsequently happen, what might describe as the BLP principle. We say it's highly debatable whether such a principle should apply when considering a domestic provision such as Part 2 of Schedule 10, which does not implement a corresponding provision of the directive. But that is particularly so where the relevant provision is unconcerned with whether or not there has been a supply for VAT purposes at all. We say that Part 2 of Schedule 10 is concerned only with the question whether, at the end of the events which are said to involve a disposal, P has disposed of its entire interest, all interest it has in the premises. And finally, even if it were appropriate to apply European principles to Part 2 of Schedule 10, the BLP principle itself is subject to significant limitations which have been articulated in various decisions of the Court of Justice. And the transaction by transaction approach is in particular inapplicable where the relevant transactions are inextricably linked, such that one would not have happened without the other, and where it would be artificial to split them. And this is just such a case as the first-tier tribunal rightly held. And moreover, the Court of Justice recently, in a case called Midibel, in very similar circumstances, endorsed this approach for the purpose of analysing an analogous adjustment regime, the capital goods scheme. Now, the commissioners seek to rely, we say, heavily on technical domestic conveyancing niceties in order to be able to claim that the disposal made by Balhousie was complete before the leaseback occurred. Midibel also rehearses a fundamental principle of European VAT law, that the question whether or not a supply has been made is not dependent on domestic conveyancing principles. And finally, in any event, the Commissioner's analysis is incorrect as a matter of Scots property law. And applying those rules to the facts of this case, we say that as the first-tier tribunal rightly found, Balhousie never disposed of its entire interest in the care home. At the end of the transaction, it still retained a 30-year lease in that property, and it continued to use the property in an uninterrupted fashion for relevant residential purposes. Now, that was a conclusion to which the tribunal was entitled to come, and is one which ought not to be disturbed without considerable circumspection. But we say, moreover, the first-tier tribunal was, in fact, perfectly correct, both in its analysis and its decision. So I start with the general concept of zero rating. Now, zero rating is not a concept known to European law as such, but it's a UK construct. It is permitted by way of a transitional exception to be found in Article 110 of the Principal VAT Directive, which is on page 1158 of your main bundle. On 158, and that allows member states during a transitional period to maintain those exemptions with deductibility of VAT which were granted as at the 1st of January 1991. There was a predecessor to that which takes you back to the beginnings of VAT, but the Principal VAT Directive takes it back to 1991. But Article 110 imposes a condition on such exemptions. Those exemptions must be in accordance with community law, have been adopted for clearly defined social reasons, and must be for the benefit of the final consumer. And the scope available to member states to retain zero rating was the subject of infraction proceedings brought against the United Kingdom by the European Commission in EC in UK, which is on page 1729. The Commission has made a number of complaints about the manner in which the United Kingdom had retained zero rating. And included amongst those was Group 8 of Schedule 5, which was the predecessor to what is now Group 5 of Schedule 8 of the VAT Act 1994. And one sees that on page 1732. Halfway down the page, one sees the construction and building provision in the report of the juge rapporteur. Now, our Advocate General Darman's opinion begins at page 1736. And in paragraph 1, he sets out the complaint of the Commission that the relevant zero rates, he says, fail the requirements of Article 28.2 of the 6th Directive, as Article 110 then was, that the retention be justified for clearly defined social reasons and for the benefit of the final consumer. And at paragraph 10 on page 739, he emphasizes that both conditions must be satisfied, and it's not enough that one or other of them be satisfied. And at paragraph 13 on the next page, one sees that his view is that compliance with the directive requires that the court, that's the Court of Justice, should be able to intervene in the event that the domestic jurisdiction's exercise of the Article 110 power might otherwise frustrate the community provisions itself. And all that one would say in my submission, that if that is to be the case, then those in authority, the relevant court, ought to be able to identify what those social reasons for the existence of the zero rating is, since otherwise it's not clearly defined. And that would fail to enable the Commission and the Court to investigate compliance with Article 110. The Advocate General then goes on to consider who is the final consumer, which he does at paragraph 14. And his opinion is the final consumer is the person who acquires the goods and services for his personal use. That is to say, as opposed to a person who acquires them for the purposes of an economic activity. So there's thus a distinction between a taxable person and a final consumer. And having decided that, at paragraphs 15 onwards, he considers the circumstances in which it may properly be said that zero rating is for the benefit of the final consumer. And at paragraph 16, one sees the argument for the United Kingdom, arguing that it suffices that an indirect benefit be obtained, which is a reference back to the United Kingdom's earlier argument to be found at paragraph 7 on page 1738, where the United Kingdom argued that it suffices if the final consumer grants an indirect benefit from the transaction, in particular by way of a lower end price. That's the third sentence in that paragraph. That was the argument that the commissioners were advancing there, although they appear to be taking a rather different stance in the present case. If one reverts to paragraph 16 at the foot of page 1740, the Advocate General tests the circumstances where this can be so, where there is in fact a benefit to the final consumer, where zero rating is used, as it is here, to apply to inputs which are themselves used to provide goods or services, which are then transferred on to the final consumer. And what he says at that very last sentence on page 1740 is the only benefit for him therefore lies in a possible reduction in the cost of the product, resulting from a reduction in cost outlays and overheads in the absence of positive tax on the inputs concerned. So again, if zero rating is to conform to the requirements of the directive, it's got to generate a cost which is reduced as far as the relevant directed final consumer is concerned. And we can pick up the decision of the Court of Justice on page 1745. Where it starts with paragraph 12, the concept of clearly defined social reasons. And in paragraph 14, it agrees that the exercise of the discretion as to what counts as a social reason is a matter of political choice for the domestic jurisdiction, the member state, which has got to be left to determine its own social policy. And that's why they've got to be clearly defined. In paragraph 15 onwards, deal with the debate as to the scope of the entirely separate requirement of benefit of the final consumer. And in paragraph 17, the court adopts the approach of the Advocate General, that the final consumer is the person who uses the supply for his personal use, as opposed to for the purposes of an economic activity. But it does accept that the provision of goods or services at a stage higher in the production chain can still be for the benefit of a final consumer if it is sufficiently close to the final consumer as to be of advantage to him. Now, how can it be of benefit? Presumably, as the Advocate General says, by a reduction in the price to the final consumer. Now, that is the Court of Justice's general conclusion, and at paragraphs 35 to 39 on page 1747, one sees the court addressing Group 8. And what it decided was that the United Kingdom had extended zero rating of land too far by applying it to commercial and community buildings and to civil engineering works. Facilitating home ownership was an acceptable social policy. And following on from EC in the UK, the United Kingdom implemented narrower zero rating provisions, which are nevertheless still those including buildings constructed for relevant residential and relevant charitable purposes. And it follows in my submission that the varies of zero rating to a person such as Balhousie, which is engaged in an exempt economic activity, the provision of care home services, has to be tested by reference to the social purpose of the zero rating benefit and the benefit to the final consumers, the residents of the care home. And how can one do that? We say, well, in the case of zero rating for care homes, the social purpose is clearly to reduce the costs to the final consumers, the residents of the home. Were the operator unable to zero rate its acquisition, that VAT would necessarily become a cost component of the charges paid by the residents. And that, of course, is what will happen here if the commissioners are successful. Now, the social reasons for exempting the supply of care home services are indicated by what was Article 13A(1)(g) of the 6th Directive, which is now Article 1321(g) of the Principal VAT Directive, which is to be found in the PDF of additional authorities at page 47 to 48 in a case called King's Crest. And at the bottom one sees Article 13A(1), which is the exempting provision of the directive, the 6th Directive. And member states shall exempt, it says, little g on the next page, the supply of services and goods closely linked to welfare and social security work, including those supplied by old people's homes, by bodies governed by public law or other organizations recognized as charitable by the member state concerned. And picking up from that, at paragraph 30 of the decision on page 51, the court sets out its views on the objective pursued by the exemption. In that regard, so far as concerns the objectives pursued by the exemption under Article 13A(1)(g), it is clear that that those exemptions, by treating certain suppliers in the general interest more favorably for the purposes of VAT, are intended to reduce the cost of those services and make them more accessible to the individuals who may benefit from them. Now, logically, we say, if that's the purpose of the exemption which will be provided by the recipient of the zero-rated supply, the purpose of providing the zero-rated supply to that provider in the first place is equally to reduce the cost to the final consumer and make those services more accessible to individuals who may benefit from them. And logically, we say, Parliament must have intended to integrate the supervision of the application of the provisions of zero rating, benefits relating to welfare services, and the provisions relating to zero rating, in order to secure that relief is afforded where the outcome will be to provide a reduction in cost to the care residents and to make those services more generally accessible to those who require them. Because to do otherwise, to have some other function other than actually regulating the ability of the care residents to acquire those costs, would be to undermine the reason for providing the relief in the first place. So with that being the background to zero rating, I can turn on to the legislative context more generally and take you to page 1034 of the main bundle. (1033) to 1034, and that's the varies for zero rating under domestic law. Where a person supplies goods or services which is zero rated, then whether or not that would otherwise be chargeable, no VAT should be charged on the supply, but it should be treated as otherwise as a taxable supply, and accordingly the rate at which VAT shall be charged shall be nil. And 30 subsection 2, a supply of a description within, for a time being specified in Schedule 8 is a zero rated supply. Now, the general exemption for the supply of land is to be found in Schedule 9, Group 1 on page 1059. Subject to certain exclusions, the supply of an interest in land is exempt from VAT under item 1. The supplier therefore cannot charge VAT on that supply, but correspondingly is unable to recover the VAT incurred for the purposes of the supply. And we say that economics therefore dictates that a supplier who is unable to recover the input costs and the input tax he incurs on the supplies made to him for the purposes of supplying that land on will inevitably be driven to include the irrecoverable input tax and its cost components when fixing the price of the output supply that it's making. The burden, we say, will pass to the purchaser. Now, there are exceptions from the entitlement to exemption. In the current case, paragraph A might have been relevant because it's the grant of the fee simple in the new building, but that itself is excluded from or exempted from that exclusion by little 2, where one sees the grant of a fee simple in the new building, which is intended for use solely for a relevant residential purpose or relevant charitable purpose after grant, does not fall within the scope of that exclusion. The relevant zero rating provision is at page 1053. And it's Group 5, and our particular case, we're within item 1. Group 5, item 1, zero rates the first grant by a person constructing building. In this particular case, that was Fascali, which is intended for use solely for a relevant residential purpose. And note 4 defines use for a relevant residential purpose on page 1054. And one sees paragraph B of note 4, use for a relevant residential purpose means as a home or other institution providing residential accommodation with personal care for persons in need of personal care by reason of old age and so on. So the supply by Fascali to Balhousie fell within Group 5, item 1, whilst the onward supply by Balhousie to Target fell within Schedule 9, Group 1, and was exempted. The operative part of Group 5 falls into 4 separate parts, items 1 to 4, each of which deals with a different kind of supply, which is to be given the benefit of zero rating. Item 1 deals with the first grant of a major interest in land, we've seen that. Item 2 deals with supplies of construction services. Item 3 deals with conversion supplies to relevant housing associations. And item 4 deals with the supply of building materials to a person to whom the supplier is also supplying services. And in each case, the supply is only zero rated if the building is intended either as a dwelling or for relevant residential or relevant charitable purposes. And all four of those items, all four of those types of zero rated supplies are subject to the adjustment mechanisms in Part 2 of Schedule 10. Now, winding up on Group 5, one needs to look at Note 12 on page 1056. Note 12 imposes further conditions on the availability of zero rating under Group 5. First of all, paragraph A makes the supply of construction services or the supply of building materials under items 2 or items 4 as zero rated only if they are made to a person who himself intends to use the building for the relevant residential or relevant charitable purpose. And then paragraph B, which applies to supplies under any of the four heads, requires the recipient of the supply to give the supplier a certificate stating that the grant relates to a building which is intended for use either for relevant residential or relevant charitable purposes. And the effect of Note 12 is that a supplier cannot zero rate his supply unless he's provided with a certificate that the building is intended for such use. Or in the cases of items 2 or 4, he also knows that he's making the supply to a person who himself intends to make such use of the building. And even if the supplier receives such a certificate, he still has to assure himself that the customer does indeed have that intent. And therefore, this is a pertinent example, contrary to the assertions of the commissioners, where the legislation requires a consideration of the subjective intentions of the recipient of the supply and is not merely satisfied by objective fact. It's got to be told what the intention of the relevant person is. So we can then move on to page 1064 and to the supervisory provisions, Part 2 of Schedule 10. Now, paragraph 35 of Schedule 10 makes no distinction between zero-rated supplies of land and zero-rated supplies of services or goods. Provided the relevant zero-rated supply is one relating to land and is relating to a building intended for use either for relevant residential or relevant charitable purposes, the supply is susceptible to clawback under paragraph 37 if there is a disposal or change of use of a kind described in paragraphs 36.2 and 36.3. So that it begins to be used wholly or partly for a purpose other than the relevant residential purpose or relevant charitable purposes. The provisions aren't, as I say, concerned with dwellings, but they are concerned with buildings which are intended for one of the other two approved uses, which will attract a zero-rated supply under Group 5. And what Part 2 does is to shift the focus onto the recipient of the zero-rated supply, as one can see at paragraph 37 on page 1066. And it does that by the common technique of treating the customer as making a standard-rated self-supply at the time of the relevant event which triggers the operation of the provisions. That is to say that if, in fact, he disposes of the property, or if he begins to use it otherwise than solely for relevant residential or relevant charitable purposes, then at that moment, he is treated as disposing of his interest, right, or license, which he holds immediately prior to the time of the trigger event. And the result of that is that P has to account for VAT on the deemed supply to HMRC, but he has the right to recover input tax to the extent that the building is thereafter used for taxable purposes. So provided he is able and has the sense to, for example, opt to tax before he disposes of his interest, right, or license in the premises, or provided he decides to use the property thereafter for purposes of a taxable trade, he will not suffer a clawback because he will be entitled to match his output tax liability by reference to his input tax recovery. Contrast that with the position that we have here, where Balhousie, having declared that it was to use the premises in the way dictated by Group 5, and having issued a necessary certificate under Note 12 of Group 5, and having continually used the premises for relevant residential purposes, not only up to the time of the supply, but also after the alleged deemed self-supply, nevertheless finds itself in a position, according to HMRC, where it is itself liable to account for output tax with no input tax recovery, simply because it financed its acquisition by a sale and leaseback transaction. And if one tests that proposition of the Commission by reference to the social purpose of the zero rating legislation, we say it's utterly unmeritorious. Does the manner in which the person who receives rating continues to use the property in conformity with the purpose of the legislation? The answer is yes. Does the recapture of the benefit of zero rating achieve the purpose of the zero rating legislation? And the answer is equally no, because the inevitable result of imposing a tax charge in circumstances where Balhousie continues to provide such services of an exempt nature to the care home residents is that it will have to increase the cost to the care residents and make them less accessible to those who require such services. And in those circumstances, one should, in my respectful submission, treat with the utmost scepticism the Commissioner's argument that one must impose that charge on the appellant simply because it carries on business within the building with the benefit of a different interest in the property from that which it held at the time of the original supply. Next, I turn to the transactions themselves and draw attention to specific elements of those transactions which we consider are relevant for present purposes. And there were a number of transactions. They had to take place at the same time because the later transaction, the sale and leaseback, was the means of financing the earlier transaction, the sale by Fascali to Balhousie. Because the Fascali and Balhousie were companies in the same corporate group, they didn't exchange missives for the sale. But sometime, and sometimes the sale and the steps were taken. Fascali had constructed the care home on the Huntley site. That was completed in November 2012, after which Balhousie Care Home Limited went into occupation of the property as a care home. Now, missives were exchanged between Balhousie and Target, creating a single agreement for the sale and leaseback. The acceptance is to be found at page 531 from Messrs. Gately, and one sees there that they accept the terms of the offer on behalf of Target Healthcare. And they accept the offer of the same date, 8th of March, which is to be found on page 532. And taking you through this particular letter, one sees on page 533 in the definition clause, the date of entry means the 8th of March, or such other dates as may be agreed. The date of settlement is defined as the date on which settlement was actually effected, and there's no dispute that that was also the 8th of March. And then on page 539, in clause 4, one sees a heading date of entry, and one sees it says this: subject to the seller's, at Balhousie's, right of occupation and possession of the properties conferred by the leases, the seller shall give the purchaser entry to and actual vacant possession of the whole of the properties on the date of entry, the giving of such possession being an essential condition of the missives. So Balhousie's provision of entry to target was subject to Balhousie's own rights of occupation and possession under the lease. Target never takes entirely free from Balhousie's rights. Those are the fundamental basis on which it acquired ownership. Balhousie never goes out of occupation, but continues to occupy and use the premises as a care home, as the parties had agreed, and as we shall see, as the parties indeed required. Moving on to page 541, clause 10. On the date of entry, targets to pay the price, and in exchange for the payment of the price, Balhousie is to deliver to target both the dispositions and a clause 10.1.13 on page 543. It's also to deliver the leases validly executed. And by clause 11 on page 544, target is obliged to grant the leases of the property to Balhousie with effect from the date of settlement. And by clause 11.1.3, the provisions of the leases, which include Balhousie's right of quiet enjoyment, were to apply to Balhousie's occupation of the premises from and after the date of settlement, whether or not the engrossed leases had by then been executed or completed. So again, it's all rolled up inside each other. The executed lease may be found at page 455. And if one starts at page 460, clause 1.1.4 defines the approved use of the premises, and one sees immediately that the approved use by Balhousie is going to be use as a residential care home and or nursing home. And then page 465, clause 1.1.47, the term is a term of 30 years, and 1.1.48, the term commencement date is the 8th of March 2013. Then on page 467, clause 2, the grant and rent, it lets the property to Balhousie for the term. And then page 483, amongst the conditions of Balhousie's right to the lease is Balhousie must 3.16.1 not use the premises other than for the approved use, that is to say, as a care home. And finally, page 493, clause 4.4, target undertakes that if Balhousie makes the payments reserved and observes and performs its obligations and the conditions in the lease, that Balhousie may quietly enjoy the premises without any interruption by the landlord during the term, which of course was to commence on the 8th of March. Balhousie executed that lease on the 7th of March and target did so on the 14th of March. And if one can then turn to the decision of the tribunal, start with the conclusions of the tribunal on page 177. Paragraphs 77 to 79. Might I invite you to read those? So the sale and leaseback was a composite whole, forming a commercial unity. One would not have happened without the other, and the transaction was a financing transaction, an alternative bank lending. That was the reality of the position, the transaction, and in the premises, the transaction did not fall within paragraph 36.2. And in arriving at these and making these findings and arriving at these conclusions, the tribunal had heard witnesses, which if one looks at page 164, paragraph 3, the very last line 33, 34, the tribunal describes the evidence given by the witnesses as credible. And it sets out the facts at paragraph 6 onwards. And in paragraph 6, it makes its finding in relation to the finance aspect. In view of the difficulty, it says on page 165, line 3, at that time of obtaining bank finance, a previous used mechanism for selling properties and leasing them back was adopted for 3 properties, of which Huntley was one. And the funding model was said to provide funding for growth and to allow Balhousie to focus on its core capabilities of providing care. Now, the Commission may invite you to disregard those findings and conclusions on the basis that they were somehow infected by errors of law, that they are conclusions from the primary facts rather than the primary facts themselves, and that they can therefore be disregarded. They will, I anticipate, say that once there had been a sale of the ownership of the property, that sufficed for paragraph 36.2 purposes, whatever else might have been happening. And my submission is, of course, that that argument ought not to be accepted. But even if there were any merit in the Commissioner's argument that some of these findings are derived in part from other findings of fact, which we say is highly debatable, they would still fall into a special category described by Lord Walker in the House of Lords in the College of Estate Management case, which we can pick up at page 1572. And if I could invite you to read paragraphs 35 and 36 at the bottom of 1572. And what had happened in College of Estate Management was that the question had been whether or not the supply made by the college involved a separate supply of zero-rated printed matter, or was a composite supply of education of which the printed matter formed a part. And the VAT Tribunal had decided, and one can see this at page 1568, paragraph 62 and 63 between F and H, that there had been an overall supply of education, a composite supply of education. At page 1570, the Court of Appeal through Lord Justice Ward had criticised the tribunal for assuming there was such a single supply, and then decided there were 2 distinct supplies, one of which was the exempt supply of educational services and the other zero-rated supply of goods. That's at line C, note C, just below Principles in Car Protection Plan. So he turned the matter on his head and said there were separate supplies, one of which one was a zero-rated supply of books. And then at paragraph 31, on page 1571, the question for the point that the tribunal had made was that the supply of books was in fact ancillary to the supply of education, and what Lord Walker says was, well, this is the only point on which I can find any significant error of the approach of the tribunal. The evaluative findings which the tribunal made at 60-63 above were conclusions which were open to it on the evidence. And it's against that background that he then engages in the general observation by reference to what was said in the Bainan case. Now, in this case, in my submission, the first-year tribunal decided that there was a composite supply of less than the entire interest of the taxpayer, and it was that finding that was displaced on appeal. It's fair to say that neither the upper tribunal nor the inner house had the benefit of the decision of the Court of Justice in Middelburg, to which I shall come. And had they done so, one might reasonably have understood the decision of the first-year tribunal to be one to which it was fully entitled to come, and which ought not, in the words of Lord Walker, to be disturbed on appeal without a considerable degree of circumspection. But the upper tribunal and the Court of Session proceeded on the basis that it was impossible as a matter of law for such transactions to be treated as a composite transaction. And I say we know now, following Middelburg, that that is not so. Now, that being the case, I can now take you back to part 2 of Schedule 10 on page 1064. To complete the application of those provisions in this particular case. And we accept, of course, that those provisions are capable of application because the requirements of paragraph 35 have been satisfied. The relevant zero-rate supply was that made by Fascali of the care home to Balhousie, although one notes in sub-paragraph 3 that in this case P is technically Balhousie Holdings Limited because it's the representative member of the VAT group, but nothing turns on that. And the triggers for the operation of the self-supply charge in paragraph 37 are to be found in paragraph 36. Now, paragraph 36.1 operates in an extraordinarily cumbersome manner, which looks at whether or not there has been an increase in the proportion of the relevant premises, which falls within paragraphs 36.2 or 36.3, which causes an increase in the proportion of the premises, which exceeds the proportion which previously fell within those subparagraphs. Now, most of that's linked to measuring the value of the deemed supply, which is not something with which we are concerned. And then paragraphs 36.2 and 36.3 deal with the circumstances in which there may be such an increase as is mentioned in 36.1. And the first, which is paragraph 36.2, is where P has disposed of P's entire interest in the relevant premises or part. And the second, which is paragraph 36.3, is where the premises don't fall within sub-paragraph 2, which we say means that P hasn't disposed of his entire interest in the premises, and they are being used for purposes of neither a relevant residential purpose nor a relevant charitable purpose. And that can apply where P starts using a part of the premises in a different way, as well as where it uses the entirety of the premises in a different way, or uses them less for relevant residential purposes than was previously the case. And superficially, paragraph 36.2 is concerned only with those two matters, the disposal of P's entire interest in the relevant premises and the use made by the premises. And premises are defined by paragraph 35 as the building or part of the building in relation to which a relevant zero rating supply has been made to P. And putting the matter in a slightly different way, the questions being asked by those subparagraphs are, has P given up all interest in the building so that it no longer has any interest in the building? And even if P still retains an interest in the building, has P's use of the property changed, though it is no longer being used in a way which wholly conforms with the intention of Group 5 of Schedule 8? And the commissioners rely on that dichotomy between the two paragraphs to suggest that if P disposes of its interest in the property, but the property is still being used in the approved way, then that too leads to a charge. And we accept that if P were to dispose of its entire interest to a third party, who thereafter exploited the property in circumstances where P was thereafter excluded from the property and used them for his own purposes, that would cause a clawback under Part 2, whatever the transferee did with the premises going forward. But there is no reason to assume that where P retains an interest in the premises, even one which is granted to it in the course of a sale and leaseback transaction, that should be seen as a disposal of its entire interest in the premises. It is, we say, the very opposite. Subject to the most technical of arguments relying on technical niceties of conveyancing in individual parts of the United Kingdom, there is never a moment in this case where Balhousie was not entitled to a very significant and major interest in the premises, was in occupation of those premises, and continued to use those premises for the right purposes, and retained, going forward, a major interest in those premises, which, had it been granted by Fascali to Balhousie in the first place, would itself have attracted zero rating under Group 5. And leaving the conveyancing niceties on one side, since that's a matter to which my learned friend Mr. Simpson, Queen's Counsel, will address the court, it will be observed that Part 2 goes out of its way to avoid the concept of supply as a trigger for its operation. It does not require a supply for its application, so that P could, for example, make a disposal which was not a supply, such as giving the property away. Because under Section 4 of the Act, anything which is done otherwise than for a consideration is not a supply. Or it could start using the property in whole for an unacceptable purpose, which would not involve any supply either. And given that divergence from the usual manner in which VAT is charged, there are solid reasons for assuming, first, that there is no need for the usual rules to apply when considering paragraph 36.2. And secondly, for investigating what the real thrust of the legislation is. It would be very odd, in my respectful submission, to be focusing on the need for each supply in a chain of transactions to be separately considered, if there is in fact no need for a supply before the provisions are engaged. And yet, with the exception of the first-tier tribunal, which we respectfully submit achieved the right analysis for the right reasons, the other tribunals and courts which have considered this matter have thought themselves bound to consider the application of Part 2 by reference to the principles which ordinarily apply to chains of transactions. And I say ordinarily because recent European jurisprudence indicates that even in the context of standard VAT analysis, that general analysis sometimes gives way. And the issue before this court is whether it is right to say that for the purpose of paragraph 36.2, P had disposed of its entire interest in the relevant premises. And in my submission, the way in which both the upper tribunal and the inner house addressed this ignored and disregarded the word entire. Because if one adopts the arguments, as I understand them being advanced by the Commission, the grant of a lease out of the right of ownership would not involve the disposal of the right of ownership. It would be a completely different right. So on that basis, paragraph 36.2 could be worded, should be worded, where P disposes of his interest in the premises, since entire would then add nothing. Because the case where he disposes of his interest in part of the premises is already separately dealt with. Is does he dispose of his entire interest in the whole of the premises or the part of the premises in question? So what then does the word entire add to the test in paragraph 36.2? In my submission, the obvious effect is to draw a contrast between the case where P has some interest in the property after the transactions have occurred, with a case where going forward he no longer has any interest in the property. Now, the Commissioner's case, as I say, is based on the need to consider supplies separately. And it was this approach which attracted the inner house, which we may see at page 114 of the bundle, paragraphs 15 to 21, where one sees halfway down the page, heading General Principles of VAT. And what they were relying on were the line of cases beginning with BLP in the Court of Justice and ending with the decision of the House of Lords in Robert Gordon's College. So the inner house in paragraphs 15 onwards sets out various propositions, 4 general principles, it says. And the first of those is in sentence 2, the assumption that VAT applies to every sort of economic activity unless there is a specific exemption or a specific provision for zero rating. Now we accept that, but it is irrelevant here because one is not concerned with the need for economic activity. Part 2 of Schedule 10 applies to charities, for example. And charities may well not be engaged in an economic activity, but would still be susceptible to clawback under paragraph 37 if they started using the property otherwise than for relevant charitable purposes, or if it disposed of the property without more. So part 2 applies not only to businesses such as Balhousie, but also to charities. The second proposition is that VAT applies to individual transactions in the chain of transactions that ultimately results in the supply of a good or service to a consumer. But again, this case is not concerned with whether there is a chain of transactions resulting in a supply to a consumer. The supervisory provisions apply without any such chain of transactions. And even when they do apply, they apply by creating a deemed supply and not by relying on a real supply. The third proposition is fiscal neutrality. Fiscal neutrality, all economic activities, whatever their purpose or results, are taxed in a wholly neutral way. Well, we know that's not true of the zero rating of care homes, because the supply is only zero rated if the recipient intends to use the property in the approved way. Why should one ignore the intention of the taxpayer for the residue of the specified period, when that's precisely what the zero rating provisions demand to know when granting the zero rating in the first place? In this way, it says, the ultimate burden of the tax is passed on through successive stages to the final consumer. Again, it is very difficult to see what relevance that has, where one is concerned with a provision, Route 5 of Schedule 8, relating to the provision of a property which is going to be used as a care home, where the whole thrust and purpose and social purpose is to ensure that the final consumer should not bear the tax. And finally, in analysing construing transactions at each stage in process, this is objectivity at the top of page 115, of production and supply of a good or service, the court must adopt a strictly objective approach. But again, the supervisory provisions in Part 2 of Schedule 10 are not concerned with such an analysis. They are concerned, as I said already, with a case which may or may not involve a chain of transactions, or with stages in the production of supply of goods or services. They are concerned with whether or not the propositus still has an interest in the property in question, and with whether or not it's still using the property for the relevant residential or relevant charitable purposes. So we say it is a matter of significant concern that the manner in which the Court of Session came to its conclusion was by reference to general principles which really have nothing to do with the case in front of it. Then in paragraph 16, the court turns to the BLP analysis. One sees halfway down the expression of the fundamental basis on which the tax is imposed, the ideal chain of transactions. And at the end of paragraph 17, having referred to the approval of the Advocate General's opinion in BLP in Robert Gordon's College by Lord Hoffman, but just before paragraph 18, it sums that up. It says each transaction in a chain of supply must be examined separately to determine whether there is a direct and immediate link between the supply made by the taxpayer to the taxpayer and the taxable transaction in respect of which it is sought to deduct input tax. But in what sense is paragraph 36 of Schedule 10 seeking to determine whether or not there is a direct link between input and output? It is not the function of those provisions. And it is therefore odd, indeed, that so much weight should have been placed on them by the inner house. What is more, putting all that on one side, the transaction by transaction approach breaks down when one is considering composite transactions. And in order to make this point, I turn to part service, which is at page 2015 of your bundle. The case involved a lease purchase arrangement relating to cars. The customer would enter into a lease purchase arrangement on which he agreed to pay taxable rentals. And at the same time, the customer would enter into what was said to be an exempt insurance agreement with another connected company, for which the hirer made payment up front, and which appears, amongst other things, to have reduced the price payable under the leasing arrangement to a sum little greater than the cost of the car to the lessor. And the questions for the Court of Justice are at page 2020, paragraph 32, and it's the second question which is relevant here. And it's framed in terms of abuse of rights, as one sees. But before moving on to Halifax and the issues of abuse, the court considers more general principles of single or multiple supplies, as one can see at paragraph 48 on page 2022. One sees it's into the second question, and before it reaches whether or not, for the purposes of the application of VAT, paragraph 46, transactions can be considered to be an abusive process, it starts off with preliminary points. And the question is put at paragraph 48, whether it should be considered to be a single transaction or several individual and independent supplies of services requiring separate assessment. The classical authorities are mentioned, CPP and Lvov, in paragraph 49. And the normal rule is then set out in paragraph 50. Every transaction must generally be regarded as distinct and independent. And then paragraphs 51 to 53 address the exceptions to this. The classic principal ancillary case in paragraph 52. And in paragraph 53, the Lvov example, where two or more elements are so closely linked that they form objectively a single indivisible economic supply, which it would be artificial to split. And the extra step that existed in part service was, of course, that there were supplies being made by different people rather than two supplies which were said to be independent being made by the same person. And despite that, in paragraph 54, what the court says is you can move beyond the contractual structure of the transaction if the evidence before the court discloses the characteristics of a single transaction. And then at paragraph 55, it goes on to say, if it helps, you can see whether there's an abusive practice involved. In that context, it may find it necessary, that's the domestic court, to extend its analysis by seeking evidence of indications of the existence of an abusive practice, which is the concept with which the question referred is concerned. And it doesn't say it will be necessary. And it doesn't say that in order for two elements of transactions carried out by different people to be treated as a single transaction, it has to form part of an abusive structure. Now, it's absolutely right to say that the rest of this particular case goes on to analyze it in Halifax terms. But in my respectful submission, as we will see soon, that same principle has been applied in other cases where there is no abuse. One of those is NEC and one of those is Midibel. And the next case is therefore NEC, which is at page 2067. NEC operated various venues which were used to stage concerts and similar events. And what it would do would be to hire the venue to the promoter, and it would then sell tickets for the concert to members of the public in the name of and on behalf of the promoter. It would then charge the customer a booking fee, which it would retain, and would pass on the ticket price to the promoter. So there were two independent organizations, each making supplies to the same person, one of which was arguably exempt, which was the supply made by NEC, and the other of which was undoubtedly taxable, which was the supply of the sale of tickets made by the promoter. And if one goes to page 2070, in paragraph, one sees that the Court of Justice observed that NEC did not at any time take ownership of the tickets as agents for those promoters, which is code for it wasn't responsible for accounting for the VAT on the tickets. That was down to the promoter because it didn't take ownership. And the principal issue referred to the court by the UK courts was whether the issue of the card processing fee was an exempt supply. And the questions referred are to be found at paragraph 16 on page 2072. We don't have to worry too much about that, because when one goes to paragraph 17 at the foot of page 2072, one sees that before the court decided whether or not that was so, it considered there was a preliminary issue in relation to which it makes preliminary observations. And that's paragraphs 17 to 24. And in paragraph 17, the court challenges the initial assumption of the domestic court that there were two separate and independent services here. And in paragraphs 18 to 22, it refers to its previous jurisprudence, Everything Everywhere. And down in paragraph 22, one sees part service mentioned. So entirely detached from the question of abuse, the court asks the first question, well, did you have a single supply anyway? Because if you did have a single supply, which was basically tickets or something like tickets, then that was a taxable supply. And then the card processing services, even if otherwise they would be exempt, will take their VAT characteristics from the principal supply. And if I could invite you to read paragraphs 22 and 23. And then it says, subject to that reservation, we'll answer the question that was actually asked. But what is being said there is the National Court has to decide whether or not there is a single transaction, that's paragraph 22, having regard to the economic and commercial reality of the transactions in question. And then in deciding that, it goes on to deal with card protection plan and then the Voiskova case, paragraph 31. Now, the Court of Justice appears wholly untroubled by the possibility of two separate taxable persons making a single supply between them in circumstances where abuse was not involved or mentioned. And if we could just pick up the Voiskova case, that's at page 2062, we need only look at paragraph 31, on which NEC was relying. And one sees the standard CPP-Lvov analysis being trotted out again by the Court of Justice. So NEC was a case where separate supplies made by independent persons were so inextricably, or could have been said. My Lord,
Last page number.
2062.
Paragraph.
31.
Thank you very much.
I apologize.
No.
I had my sound off because I was being told I was suffering feedback. But so NEC was therefore another case where separate supplies made by an independent person were so inextricably linked that it was going to be open to the domestic court to find there was a single supply, or it could do so. So by the time that Midibel was reached, the Court of Justice had indicated that the separate transactions rule in BPP gave way to CPP and Lvov, as articulated in Voiskova, applying not only where one was considering a single supply made by a single person consisting of a number of separate elements, but also when considering the proper analysis of the number of transactions entered in by different people, even independent people, whether or not there was any abuse. And if one therefore sees NEC as a case which involves two separate transactions going in the same direction in an arrow way towards an individual recipient, Midibel is a case where those transactions go in opposite directions, one from supplier one to the purchaser and one from the purchaser to the supplier. And where those two transactions can be treated as a single transaction and between them prevent the transaction amounting to a supply of land, or here amounting to the disposal of P's entire interest in the land. And Midibel starts at page 2080. And in Midibel, the taxpayer participated in two sale and leaseback transactions in relation to two of its trading premises with two financial institutions. And if one goes to paragraph 12 onwards on page 2083, one sees that paragraph 12, Midibel had deducted in full the taxes charged on the construction, alteration, and renovation invoices relating to those buildings. And then on paragraph 13, in October 2009, in order to increase its liquidity, Midabel and two financial institutions entered into sale and leaseback transactions, not themselves subject to VAT, well, they would be exempt, relating to those buildings. And the first transaction with each of the financial transactions involved Midabel granting a 99-year emphyteutic lease to the financial institution in return for a premium and subject to the payment of rent. And the second transaction, which was entered into between the parties, was the grant of a lease back by the financial institution to Midabel for a term of 15 years, an irrevocable period of 15 years, which gave Midabel the use of the buildings in return for the payment of quarterly rent corresponding to an investment value equal to the amount which had been paid in the first place, plus interest. And you will note that at the end of the agreement, Midabel enjoyed, at the end of the lease, the right to buy the property back for a relatively modest amount. So what one has in Midabel is rather further away from our case, in that it involved two separate agreements, admittedly exchanged at the same time, but nevertheless two separate agreements, which, if one adopted the Commissioner's argument here, would mean that one had to consider those two separate steps independently. And since the first involved the disposal of the entire interest that Midabel held, or at least it involved the disposal of the 99-year lease, that would amount to the grant of a lease for VAT purposes. Now, paragraph 14, following a VAT inspection, the Belgian tax authorities disallowed the initial deduction of rent. That's the amount that Midabel had originally deducted in the construction of the buildings, on the basis of the sale and leaseback transactions. And the rule, sorry, again, the issue for the court was whether or not the general rules for an initial deduction in Articles 184 and 185, or the capital goods scheme rules in 187 to 188, operated to require either the disallowance of the input tax deduction or its adjustment. And one sees those rules in paragraph 6 onwards at page 2082. And one sees in paragraph 6, the initial deduction shall be adjusted where it's higher or lower than that to which the taxable person was entitled. And 185, it shall be made where some change occurs in the factors used to determine the amounts to be deducted. And then moving down, one sees the capital goods scheme rules in Articles 187 and 188 at paragraphs 9 and 10. So in the case of capital goods, adjustment shall be spread over 5 years, although one sees it can be up to 20 years in the case of immovable property. And paragraph 2 of Article 187, the annual adjustment is made in relation to 1/5 of the VAT charged on the capital goods, or a corresponding proportion if the period used is longer. And then 188, if supplied during the adjustment period, capital goods shall be treated as if they've been applied to an economic activity up to the expiry. And then after that, it depends on the nature of the capital supply in question. One sees that up to the time you leave it alone, and once the supply has taken place, the economic activity is either treated as fully taxable if the supply made on is fully taxable, or is fully exempt if the supply of the capital goods is fully exempt. And you make that adjustment, says Article 1882, only once. Now, the latter provisions, Articles 188 and 189, correspond to our own capital goods schemes, which are to be found, and we may as well take this now, at page 1108 of the bundle. Regulations 112 to 116 deal with the capital items adjustments, and they apply to land. And if one goes to the adjustment provision, which is paragraph 115 at page 1113, one sees that regulation 115.1 says that if in a subsequent interval the amount of use that you make of the item increases, then you're entitled to adjust a proportion of the input tax or recover an extra element of input tax by reference to that relevant interval's input tax proportion, 1/10 of it. Regulation 1152 deals with the case where you carry on using it, but you use it less in making taxable supplies, at which point you have to make an adjustment downwards of the amount of input tax you're entitled to by reference to the period for which you make less use of it. And then regulation 1153 deals with a case where during an interval other than the last interval, the owner A supplies the whole or part of his interest in the capital item. And that's the middable case. So the question is whether or not in a case like this, a sale and leaseback transaction, the owner is treated as having supplied the whole or part of his interest. And if one reverts to page 2083 in Midibel.
Mr. Thomas, you'll be remembering that we were intending to take a brief adjournment. Do you want to finish dealing with Midibel first? Or would this be a convenient point?
If we take an adjournment now, then perhaps we can address the thrust of Midibel afterwards, if that's convenient.
Well, it's an important part of your submission, and we should look at it carefully. Thank you very much. We'll adjourn now for 5 minutes. That simply involves switching off video and muting one's microphone.
Thank you.
Thank you very much. Mr. Thomas, please continue your submissions.
Thank you. We were just reverting to Midibel to page 2083, paragraph 14, which is where, as I said, the Belgian authorities disallowed the input tax on the basis of the sale and leaseback. And what effectively the Belgian authorities were saying is that the grant of the longest possible lease under Belgian law, an emphyteutic lease for 99 years, amounted to an exempt supply that needed to be taken into account for the purposes of Articles 184 and 185, or amounted the supply of capital goods under Articles 187 and 188, because it breaks the chain of transactions. It's an exempt supply. The inputs are used for the purpose of making an exempt supply. And in paragraph 27 on page 2085, well, one might start with paragraph 26. One sees the case law of the court that the use to which the goods or services are put determines the extent of the initial deduction. And then it says in paragraph 27 that the adjustment provision in those provisions is an integral part of the VAT deduction scheme and is intended to enhance the precision of deductions so as to ensure the neutrality of VAT. So that transactions effected in an earlier stage continue to give rise to the right to deduct, only to the extent that they are used to make supplies subject to VAT. And in our submission, that's actually an apposite description of the supervisory provisions in Part 2 of Schedule 10. But what they are designed to do is to enhance the precision of the provision of zero rating benefit to make sure that the recipient of the zero rated supply only enjoys the benefit of the zero rated supply to the extent that it continues to use the capital item during the relevant period for the appropriate purposes. And in paragraphs 28 and 29, the court deals with the Commission's argument, which was really adopting the position of the Belgian authorities, that the grant of the lease was itself an exempt supply which broke the chain. So there was no right to deduct from the output. The Commission's argument essentially, as I say, was, well, Middelbel may have intended to use these premises for the purposes of its taxable trade, but what it actually did was to make an exempt supply of that. Knowing that it had made an exempt supply by the grant of an emphyteutic lease, one ought to deny the initial deduction because of the intervening exempt use. Or alternatively, coming on to the capital goods scheme adjustment, this was a supply which fell within Article 188, to which the court will shortly turn. But what the court did in paragraphs 29 to 30 was to look at the transactions to see that Middelbel had continued to use the transactions carried out for the purpose of construction for the purposes of its own taxable transactions. This is tab 28. So there were no changes in the factors used to determine the amount of deductions made after the VAT return was made. And contrary to what the European Commission claims, the mere grant of that lease can't be regarded as a change in those factors because it didn't have the effect of breaking the close and direct relationship between the right to deduct input tax and the use of the goods or services. So that established that Middelbel's first right to deduct wasn't taken away from it by the fact that it had subsequently used it for some other purpose as well. But then in paragraphs 31 onwards, and more importantly, the court turned to the question of, well, do these transactions fall within the capital goods scheme rules under Articles 187 and 188? And in paragraph 33, the test which is imposed by the Court of Justice, or what it refers to, is that under Article 188, capital goods are to be treated as if they've been applied to an economic activity up to the expiry of the adjustment period. And in 34, it then says, well, we're not looking at domestic conveyancing rules in deciding whether or not there's such a supply of goods. A supply of goods is looking at the transfer of tangible property by one party, which empowers the other party, that is the recipient of the supply, actually to dispose of the tangible property as if it were its owner. And in paragraph 36, the court notes the combined and simultaneous grant of the lease and lease back. And in paragraph 37, it then decides whether or not that grant of the lease and the lease back must be considered separately or together. And then in 38 and 39, the court refers to part service. And applies the usual LeVob CPP type rules to say, we will have a single supply where two or more elements supplied by the taxable person to the customer so closely linked they form objectively a single indivisible economic supply which it would be artificial to split. And 39, it obviously tells the National Court that it's for the National Court to make that decision. But then in 40 and 41, it goes on and gives appropriate guidance to the National Court to enable it to make that decision. And it sets out in paragraph 40 what the order for references said, that they are purely financial transactions designed to increase Middelbel's liquidity, and that the buildings remained in the possession of Middelbel, which used them in an uninterrupted and permanent way manner for the purposes of its taxable transactions. And it concludes, or tentatively, that those facts, those two facts, appear to indicate that, subject to verification by the referring court, each of those transactions, that is the sale and leaseback transaction, form a single transaction, since the creation of the emphyteutic right over the buildings is inseparable from the leaseback. And therefore, paragraph 41, they constitute a transaction. And from that, it concluded that Article 188 was not engaged because what had happened should not be treated as a supply of goods, because the rights transferred to the financial institutions, reduced by the rights which were granted under the leaseback agreement, separate leaseback agreement, of which Midabel was the beneficiary, did not empower the financial institutions to dispose of the buildings in the main proceedings as if they were the owner. So there was no supply of the interest of the trader in the premises, because once that so-called single transaction was complete, Midabel still had an interest in the property and was continuing to use the property for the purposes of its taxable trade. The lease and leaseback, says the court, were inseparable, and they have got to be treated as a single transaction. They are a financing transaction and would not have been granted without the other. Midabel was not going to grant that lease to the financial institution unless it was absolutely certain that the financial institution was going to grant the lease back to Midabel. They were inextricably connected with each other. Now, of course, the financial institution could have sold its emphyteutic lease, but that lease would not have given the acquirer the right to occupy and use the buildings, the tangible property. It would simply have given it the right to exploit the income rights derived from the property interest it had acquired. And if one puts that in Regulation 113 terms, in UK terms, where you have to treat such transactions as forming a single transaction, the trader who continues to occupy and use the physical premises cannot be said to have disposed of his interest in premises. And whether or not in circumstances like that, a financial sale and leaseback transaction, there is a single transaction or two separate transactions which have got to be independently construed, is dictated by the part service approach mentioned in paragraphs 38 and 39 of Midabel, which is, as I say, an extension of the Lvob CPP approach, but applied in a case where there is more than one supplier. And as I say, in part service, the two suppliers were going in the same direction, as in NEC. In Midabel, the same answer is given, even though the transactions are going in opposite directions. And in each case, one has to ask the question, look at the economic reality of the transactions. Are the two elements so closely connected with each other as to form a unified whole? And in my submission, a sale and leaseback transaction, and especially one such as that here, which is brought about by a single contractual agreement, is a perfect example of such a unified whole. And if one accepts that it's a unified whole, and one looks at the outcome of the end of the transaction, what one can say is that he has not disposed of his entire interest in the tangible property because he still has an interest in that property, namely the leaseback. And it's a question, says the court, to be verified by the fact-finding tribunal. Would it be artificial to split those transactions? Would the sale have taken place without the leaseback? Are they inextricably linked? And in my submission, the answers to all those questions have already been given to us by paragraphs 77 to 79 of the decision of the first-tier tribunal. And those findings, one will recollect, were that the reality was that this was a composite transaction forming a commercial unity. It was an alternative to bank lending, where the one would not have happened without the other. And in my submission, in those circumstances, those being the findings of the fact-finding tribunal, not only was that tribunal entitled to come to that conclusion, it was obliged to come to that conclusion. It really doesn't matter that we are concerned with paragraph 36.2 rather than regulation 1153. In my submission, the same principles are applicable and the same result should be reached. In terms of the function of those two parallel sets of provisions, in each case, the provision is designed to produce an adjustment where the relevant taxpayer is no longer using the premises for the relevant purpose, or is using it less. In the case of paragraph 36.2, the question is really directed towards whether or not the propositus is using it for relevant residential purposes. And in the case of regulation 115.3, the question is whether the propositus is using it for purposes of its taxable trade. And if one finds that the trader is still indeed using it for the appropriate purpose and retains an interest in the property which enables him to do so, it would be wrong to decide that the adjustment provision had engaged. And against that background, in my submission, it's less surprising that in Midabel, the Court of Justice put possible objections on one side and viewed part service as an authoritative general principle, requiring several transactions to be treated as a single transaction, not only when carried out by a single person, but also by different people as part of the same overall transaction. And that was so whether or not it might be necessary for conveyancing reasons for the right of ownership to be granted to another before the lease back could be granted out of that larger interest. So there's no such general principle that each transaction must be segregated from the next transaction or from some other concurrent transaction. That is the normal rule, but it's by no means the universal rule. And where the conditions in Midabel are satisfied, the rule gives way to a consideration of the larger transaction to determine its fact consequences. I want then to move on to certain other issues which were raised by the inner house. So if we could then turn back to the inner house's analysis of regulation 36 and 37. At page 122, I say 122, but yes, at page 122, paragraph 27. The way in which the inner house described the purpose of paragraphs 35 to 37 is to prevent potential abuse. The description which it gives, this is the very last sentence on page 122, the description of which would be, for example, a building originally constructed as a residential property might be converted into commercial property relatively soon after construction. In that way, a commercial enterprise carrying on economic activity would be able to acquire premises that had originally been provided free of any charge to VAT. Well, that's abuse, but in seems to assume that a care home is not an economic activity, which of course it is. Economic activity in relation to care homes is not abusive. Economic activity not falling within an approved description is, of course, inappropriate. Then in paragraph 29 on the next page, the third sentence, the Inner House suggests that there are sound reasons for imposing the self-supply charge on P in the event of a mere disposal without any change of use. Because following disposal, the person who received the initial zero-rated supply will normally have no control over their premises or use, and therefore the transferee could change the use. In which case, it says, the self-supply charge would be imposed by paragraph 37 on the original transferee, but in respect of an act which was out with its control, which is an unsatisfactory result. I'm leaving aside the question why it would be fair in those circumstances to impose an upfront charge, which is the result at which the Inner House arrives. The argument, the analysis fails, in my respectful submission, to address the taxpayer's argument, which is that paragraph 36.2 does not apply where, after the transaction is over, the transferor retains an interest in the property. Because in those circumstances, there are two possible outcomes when a taxpayer makes a disposal of an interest in the relevant residential premises. In the one instance, it will make an out-and-out transfer, retaining nothing and having no future interest in the property. In which case, of course, we accept that there is a charge. But in the other case, the original owner will either retain a reversionary interest in the property, or it will thereafter have a subordinate interest in the property and have use of the property. And in the latter cases, the original owner either has control by reason of its superior interest, its reversionary interest, whilst somebody else uses the property, or he will continue to use the property himself, in which case there is no reason for paragraph 36.2 and 37 to engage. Now, in paragraph 30, the court suggests its approach is necessary to keep the exemptions under control. This is the fourth sentence, I apologize, beginning furthermore, about 6 lines down. And that this requires effective criteria be used to determine when an exemption does or does not apply. And at the foot of paragraph 31, the last 2 sentences, it explains why it's concerned that the taxpayer might lose control. It has concern if the leaseback terminated for a number of reasons, in which case the original owner's heritable interest would be lost, and Balhousie Care could no longer control the use of the property. But regrettably, what the Inner House appears not to have appreciated, that if the BCL lease were to terminate, BCL would at that moment have disposed of its entire interest in the property, just as if it had originally been granted a lease by Fiscali, and that lease had expired either by a fluxion of time or by default. In either of those cases, paragraph 36.2 is engaged. In either of those cases, the taxpayer would be obliged to make an appropriate return of self-supply. And VAT is a self-supply tax, and one has got to assume that taxpayers will behave properly. And to the extent that they don't, the commissioners have substantial powers of supervision and enforcement. And lastly, in paragraph 32, the Court of Session seeks to draw comfort from the fact that paragraph 37 operates by deeming P to be self-supply of the interest it had immediately before the disqualifying event. This is 1, 2, 3 sentences down, about 6, 7 lines down again. The assumption is. And it is very odd, because what it reads is, the assumption is that P has applied itself at the time of the original zero-rated transaction, at the time of the original zero-rated transaction, with the interest held immediately before the time of the chargeable event. The wording of paragraph 37, it says, thus assumes that the person subject to self-supply charge has held the property or part of the property throughout the period from the time of the original zero-rated supply until the event that triggers the charge to tax. Well, of course, we accept that P must have held an interest in the property throughout that period, because otherwise there would have been a 36(2) charge. But paragraph 37 gives no support to the proposition, if that is what's meant by held the property, that it must have held the same interest throughout. Because the purpose of paragraph 37 is to impose a deeming charge by deeming a self-supply of land. It does not require the same interest to have been held in throughout. Indeed, the wording of paragraph 37, and if one turns to paragraph 37, apologies, I'm just trying to find it. It's page 106.
(106).
1066, I think, isn't it?
Yeah.
I'm having to blow mine up. One looks at paragraph 37(1). It imposes that charge by reference to a standard rate of self-supply, but it doesn't deem it to have held the same interest throughout, because what it in fact asks you to do is to deem there to be a supply of the interest which it holds immediately prior to the time when the increase is treated occurs. Immediately prior to the time when the increase referred to in paragraph 36(1) occurs. And that, of course, is the trigger events under paragraph 36(2) or 36(3), which then leads to the increase in 36(1). So rather than looking at the interest which P held at the time of the relevant zero-rated supply, which one might well have thought would have been the wording used, it very specifically looks to whatever it happens to be at the time of the trigger event. And not only does it look at that at the time of the trigger event, but it also treats the supply as taking place immediately prior to that time of increase. That is to say, immediately prior to the moment of the trigger event. Not, as the inner house suggested, as you'll recollect, in paragraph 32 on page 125. At the time of the original zero-rated supply. And what we say of that is, first of all, why would paragraph 37 be so specific in identifying interest at the time of the deemed self-supply, unless it were of the view that that might very well be a different interest from the interest it originally held at the time of the zero-rated supply. And secondly, if the basis on which that was reckoned, and the wider was by reference to the fact that it must have held the same interest, or must be deemed to have held the same interest throughout from the time of the zero-rated supply. That is incorrect, because that is not what paragraph 37 requires. It doesn't require a self-supply immediately before the zero-rated supply. It requires a disposal immediately prior to the moment of the trigger event, whether that's a change in the use of the premises or a disposal of P's entire interest in the premises.
Would it be an exempt supply?
The self-supply?
Yes.
No, it's paragraph 37(1) prevents it being an exempt supply in its terms, my lady. was 1066 again. If one looks at 37.2, it tells us that the supply is taken to be a taxable supply, which is not a zero-rated supply.
So if you made an exempt supply, it would be outside these adjustment provisions. I'm just thinking of that in the context of paragraph 32 of the Inner House.
If one makes an exempt supply, one's not concerned with the general VAT characteristics of that exempt supply. One is simply concerned with, one leaves that exempt supply in place, but one treats oneself as making an entirely different standard rated supply at the same time, which is then valued by reference to the mechanism in paragraph 37. So they get their charge that way, and then when one looks at the supply which one actually makes, which immediately afterwards is deemed to take place, or that one is deemed to recapture, the amount of input tax that one is able to recover in relation to that self-supply will be determined by what one does with the supply afterwards, or the asset afterwards.
Yeah. Thank you.
Thank you. So we say the purpose of paragraph 37 is to impose a charge by deeming the standard rated self-supply. It doesn't require the taxpayer to have held the same interest throughout. And in those circumstances, in my respectful submission, the Inner House fell into error. And my primary submission, summing up, is that on a proper construction of paragraph 36.2, Balhousie never disposed of its entire interest in the property. And my secondary submission is that it is not open to the commissioners to argue in deciding whether or not paragraph 36.2 is satisfied, that one look at the sale without any regard to the lease back, and that their submissions based on the allegedly universally applicable European VAT rules are misconceived. First, because they have no obvious role to play in Part 2 of Schedule 10. Secondly, because those rules do not apply where there's no chain of transactions leading to a supply of product to the final consumer. And thirdly, they do not apply where there is in European terms a single transaction. Now, those are my submissions, and at this stage it becomes incumbent on my learned friend, Mr. Simpson, to make his submissions, unless you have further questions of me.
I don't think there are any questions for you, Mr. Thomas. Thank you very much. Mr. Simpson.
I'm obliged, my lord. My lords, my lady, and my lords, as my friend has said, I will be making submissions on two points. The first is the approach to interpreting zero-rated legislation, zero-rating legislation according to the domestic courts, in particular the House of Lords. And second is in relation to the relevance of Scots property law to the interpretation and application of paragraph 36.2 of Schedule 10 to the 94 Act. These submissions correspond to paragraphs 38 to 67 of the appellant's written case. In summary, my submissions are, first, provisions concerning zero rating are to be interpreted in accordance with the normal approach for interpreting provisions of domestic UK legislation. Second, on that approach, and on the basis of the wording and context of paragraph 36.2, the purpose of that provision is to protect the integrity of zero rating by making it subject to the ability of the beneficiary, in the present case the appellant, to ensure that the relevant premises are being used for a relevant residential purpose, in the present case, that of a care home. The third point is that on that basis, the relevant fact on which paragraph 36.2 depends is the state of affairs after the sale and leaseback transaction took place. And not the effect of the individual steps by which that state of affairs was brought about. The state of affairs after the sale and leaseback transaction was, of course, that BCL continued to have an interest in the care home, and accordingly, paragraph 36.2 does not apply. So that's some of my submissions on the general approach to interpretation. And so far as the relevance of Scots law, Scots property law is concerned.
Could I just ask you about the
Yes,
interpretation of legislation? One would be entitled to take into account the objectives of the parties to the transaction in relation to financing. That would be relevant as well. But this particular sequence, sale and leaseback, was a substitute for a secured loan. Now, it wasn't a secured loan. I'm not suggesting a recharacterization, but it was a financing objective.
yes, in my submission, the court is entitled to take that into account. Although in my submission, it's not necessary for the court to do that in order to reach the conclusion that paragraph 36.2 is not engaged.
Thank you.
So returning to the summary of what I'm going to say about Scots property law, my submission on that point is that, in summary, HMRC's proposed interpretation of 36.2 assumes it to be correct that under Scots property law, the rights BCL enjoys under the lease, in particular possession and use, were not part of the rights BCL had as owner. Now, my submission is that that's actually not clear in Scots property law. And in any event, the interpretation and application of paragraph 36.2 should not be based on a technical issue of this sort in the private law of one of the 3 jurisdictions in the UK. Now, I turn then to the approach to interpretation of domestic zero rating legislation. The respondent in the present case accepts at paragraph 45 of its written case on page 77, on page 77 of the bundle, about halfway down that paragraph, that the modern approach to statutory construction involves not simply giving effect to the natural and ordinary meaning of the words used, but also to consideration of the purpose behind the legislation, relying in particular on Quintervel and UBS. I'll return to UBS in due course. And then sets out some unexceptionable propositions in the rest of its paragraph 45. Now, in the appellant's written case, at page 47, with the bundle, paragraph 39, page 47 at paragraph 39, there are set out references to all three of the House of Lords cases that have discussed the interpretation of a zero rating provision in the UK VAT code. Given what appears in the respondent's written case about the normal approach to statutory construction, I don't propose to take the court to those three cases. I'll simply refer to the references that are in that paragraph 39 as demonstrating that what the House of Lords has taken or had regard to in interpreting provisions of the zero rating code, as it happens in relation to alteration of buildings, has been matters such as the ordinary meaning of the words, whether an interpretation makes sense, and reading the Act as a whole in the context in which the language has appeared. So unless the court would thinks, my lord.
Mr. Sims, can I just ask you a question about the beginning of paragraph 39 of the appellant's case? On page 47. You say that UK domestic legislation concerning zero rating of supplies can be interpreted by reference to domestic principles of statutory interpretation. It sounds as if you're presenting it as a sort of option. But do you mean must?
Yes, well, in fact, yes. On reflection, that that should read domestic legislation concerning zero rating of supplies. It is to be interpreted by reference to domestic principles.
I didn't think you were presenting it as some kind of option.
No. Sorry, my lord. That's my carelessness in the drafting of that sentence.
Yes, thank you.
Also, Mr. Simpson, the second and third cases that you cite in paragraph 39 are of some vintage now.
Yes, my lord.
And the emphasis on ordinary meaning of the words would have to be interpreted in the light of later developments, which have made it clear that taxing statutes are to be interpreted purposively like other statutes.
Indeed, my lord, and that's just what I'm going to come to now, because all I take from these cases is that yes, they they reflected, or they used the approach that applied at the time of the particular judgments, but in particular, for example, in the UBS against HMRC case.
Yes, well, I'm just making the point. I agree with you. You don't need to detain the court in looking at those cases in detail.
Yes.
And we should press on to UBS.
Thank you, my lord.
Thank you.
UBS then, the passage I want to look at is page 1652 of the bundle. UBS case, which HMRC, as I mentioned, applies, concerned tax avoidance scheme to pay bonuses to employees of UBS, and Deutsche Bank was the other appellant in that case. And in giving the leading judgment, Lord Reid, of course, made what in my submission are important observations on the interpretation of tax legislation. And so paragraph 62 is the first paragraph that I'd like to look at. As I mentioned, that's on page 1652 of the bundle. So, His Lordship says that the significance of the Ramsay case was to do away with both those features, that is to say, predominantly linguistic analysis and looking at each element in a composite transaction on its own. So first, it extended to tax cases the purposive approach to statutory construction, which is orthodox in other areas of the law. Secondly, and equally significantly, it established that the analysis of the facts depended on that purposive construction of the statute. So in Ramsay itself, the terms loss and gain, as used in capital gains tax legislation, were purposively construed as referring to losses and gains having a commercial relative, since the facts concerned a composite transaction forming a commercial unity, with the consequence that the commercial significance of what had occurred could only be determined by considering the transaction as a whole. The statute was construed as referring to the effect of that composite transaction. And before I comment on that, the other passage is, of course, paragraph 68. Paragraph 68, which is on page 1654. 1654 of the bundle. So secondly, in relation to looking at transactions realistically, looking at the facts realistically, secondly, it might be said that transactions must always be viewed realistically if the alternative is to view them unrealistically. The point is that the facts must be analysed in the light of the statutory provision being applied. If a fact is of no relevance to the application of the statute, then it can be disregarded for that purpose. If, as in Ramsay, the relevant fact is the overall economic outcome of a series of commercially linked transactions, then that is the fact upon which it is necessary to focus. If, on the other hand, the legislation requires the court to focus on a specific transaction, as in McNiven and Barclays Mercantile, then other transactions, although related, are unlikely to have any bearing on its application. So therefore, Lords and Lady, the proper approach is to establish, by reference to the purpose of the provision in question, paragraph 36(2), further the relevant fact is the overall outcome of a series of linked transactions, or is specific parts or specific individual elements of those linked transactions. My submission, of course, is that, having regard to its wording and purpose, paragraph 36.2 focuses on the overall outcome of the transactions or the facts and circumstances to which it looks. And the relevant fact is whether or not the taxable person has any interest anymore in the relevant premises. And if the taxable person doesn't, then that is the change of circumstances that leads to the clawback of the zero rating granted to a previous transaction. So the next step is how to go about giving a purposive interpretation to paragraph 36.2.
Do you mean in saying that the relevant question is whether he has any interest in the relevant premises? Do you mean in any part of the relevant premises? Because the disposal of part of it. Yep.
Yes, Milady, you're absolutely right, Milady. The disposable part is counts. Yes, that's absolutely right. So one looks to reach a proposed construction of paragraph 36.2. One must, of course, first look at its wording, and then the legislative context in which it appears, that is to say, reading the Act as a whole. One may also go on to consider extra statutory materials and background circumstances to the legislation, but in my submission, the wording and the context are sufficient in the present case. So if one looks at the wording of the provision, which appears at page 1065, paragraph 36.2, it says the relevant premises, in the present case the care home, fall, or part of the relevant premises falls, within the subparagraph of P, in the present case that's the appellant, has, since the beginning of the relevant period, disposed of P's entire interest in the relevant premises. Now there are 3 points that I would comment on. First is the use of non-technical language. Second is the inclusion of the word entire. In fact, my friend Mr. Thomas has already made submissions on that point, so I won't go over that. And third, perhaps a minor point, is the use of the past tense. So the legislation envisages that one is looking backwards to things that have happened, and that suggests looking at the outcome of those facts and circumstances, as opposed to looking at them as they come about, which the present tense might have suggested. But my purpose is the most certain word.
Yes, I was just wondering if the phrase "since the beginning of the relevant period" is also potentially a helpful part of the formula, because
yes,
at least at first sight it appears to require not merely a focus on the immediately preceding transaction, but a look at everything that's happened in what is defined as the relevant period, which one assumes is from the date of the zero-rated supply.
Yes, Lord, indeed. And
just to give an example, if one if P was to dispose of a 20% beneficial interest once a year for 5 years, you wouldn't just look at the disposal of the last 20%. You'd look right back at all 5, wouldn't you, to conclude that he disposed of his interest?
Yes, Lord. It would be the combined result of each of those 5 transactions, each of those that one would look at in order to reach the conclusion on the relevant fact, which is what is the state of affairs after those transactions have taken place.
And that might have a knock-on consequence for one's understanding of paragraph 37(1), might it not? Don't go there now if you don't want to, because you're on 36(2). But I was wondering what immediately prior to the time when the increase is treated for the purposes of having occurred meant in the context of a series of 20% transactions of the type I was using as an example.
Well, my submission on that would be if what has been transferred is 25% of the beneficial interest in the whole, 20% of the beneficial interest in the whole, as opposed to 20% of the premises.
Yes,
then
that's what I meant.
Yes, indeed, my lord. Indeed, my lord. Then the time at which it may be said that the taxable person has disposed of his entire interest in the premises is immediately after the last of those 5 transactions.
Yes.
So that would be, in my submission, the time at which paragraph 36(2) is engaged, because it is only then that it may be said that he has disposed of his entire interest. And is therefore that time at which, in terms of paragraph 37, the relevant increase incurs, that increase being in the part or portion of premises that are no longer within the zero rating purpose, and also the time of the deemed supply, that being immediately prior to the time that the change in circumstances occurs.
Thank you.
And so, if I may also just mention at this stage, in my submission, that is how the appellant's position fits in with what has been termed the transaction by transaction analysis. Because leaving aside Midabel and its effects, one looks solely at the law without Midabel, or one can see that there are three transactions in the present case. One is the first sale by Fascali to BCL. One is the second sale by BCL to Target. And the third is the lease by Target back to BCL. Each of those transactions in the transaction by transaction analysis must be classified and given its VAT consequences. And that is done by reference to the facts and circumstances relevant for that purpose. Now, so far as the first sale is concerned, the facts and circumstances relevant to it are not only the normal ones of the contents of the contract between the parties and what the parties actually do at the time of the transaction, but also facts and circumstances that arise in the following 10 years. And in my submission, the fact that those facts and circumstances in some scenarios give rise to supplies of their own that have to be considered for VAT law as separate transactions and transaction by transaction analysis, shouldn't obscure the fact that for our inquiry, all we are doing in my submission is looking at facts and circumstances relevant to the tax treatment of the first sale. Returning then to the wording of paragraph 36(2), the point I wished to make some submissions about was the fact that it uses non-technical language. So the words it uses are disposed of and interest. And those aren't technical terms in either value-added tax law or, I think, in any of the three jurisdictions in the UK, the law of property or conveyancing. So my submission has been a deliberate choice to use non-technical terms. And the question is how that, what meaning that has for our inquiry. My submission in that regard is that suggests that one should not look at these words in any particular formal way, but approach them in a more general basis. And that approach, in my submission, is consistent with what is said in the case of Sargason against Roberts by Mr. Justice McGarry. Now, of course, it's a decision at first instance, so I don't rely on it as an authority, but it helps explain my submissions, if I may take the court to that. It the argument starts at page 1279 of the bundle 1279. And if I can just say that the case involved a farmer who owned agricultural land and claimed capital allowances against his trading profits on the basis of work he had done in relation to that land. He then, in fact, gifted the land into a trust and took a lease back the day after. And the point was that if that gift and lease back meant that he had, in the words of the statute, transferred the whole of his interest to another person, he would no longer be entitled to claim capital allowances. The wording of the statute was transferred the whole of his interest to another person. But otherwise, he would continue to be entitled to claim those allowances. Now, Lord, I noticed the time, and I'm happy to break now if that would suit.
Yeah, thank you very much, Mr. Simpson. We can see what Mr. Justice McGarry made of those circumstances after the short adjournment.
Yes.
Thank you. The court will now adjourn.
I'm obliged, my Lord.
Thank you.